What's the story behind prevention of sexual harassment law in India? It's a story of a woman whose lifelong struggles laid the foundation for laws against sexual harassment at the workplace. A woman spoke first time against sexual harassment in conservative Rajasthan back in 1992, named Bhanwari Devi, who was working to stop child marriages in her community. While working for the cause, she was working to stop a 1-year-old girl child marriage. That made a lot of men angry in her community. And when she reported this incident to the local authorities, they refused to take any action. Sadly, Bhanwari Devi was gang raped by the same men as a consequence of her speaking up. This incident sent shockwaves across India, making it very clear that women at the workplace was not safe regardless of her location or the organization. This incident also was a stark example of what can happen if the government doesn't step in. As a result of what happened to Bhanwari Devi, a lot of women groups, including Vishakha, filed a case in the Supreme Court of India. They argued that sexual harassment should be considered as a violation of women's basic right to be treated equally, and that all workplaces should be responsible for preventing it. In landmark judgment known as Vishakha versus State of Rajasthan case in 1997, the Supreme Court specified rules that all workplaces were expected to follow. Although these Vishaka Guidelines were not followed by any of the organizations. It took almost a decade for a lot of individuals to collectively present a bill by the name of Sexual Harassment of Women at the Workplace Prevention, Prohibition and Redressal. And it got a green signal by the Supreme Court of India on 9th December 2013 to be applicable in all the organizations operating in India. The Supreme Court placed 3 obligations on the workplaces under the law. First, to prevent sexual harassment. Second, to prohibit it. And third, to have a robust redressal mechanism in every organization. To make sure that women could report harassment without any fear, the law defines that every organization that has more than 10 employees must have an internal committee that would handle all the cases related to sexual harassment. The committee should be led by a woman and should also have at least half of its members as women. It must also involve an expert or a representative from a not-for-profit or somebody who has been working in the field of women empowerment or prevention of sexual harassment. This law gives women an option to seek civil and criminal remedies if they face harassment at their workplace. Civil remedies involve financial compensation for victims, whereas criminal remedies involve legal actions against the harasser. Now that you know a little bit about the law and its background, it's also important for you to know why it matters. Why it matters for every one of us to know that this law exists, because any woman who's facing any kind of sexual harassment at her workplace has the right to seek help under the law, and this law also gives a complete responsibility to the organization to keep its workplace safe for all its employees, especially women.